Hello, I am Advocate Rajesh Tekale, practicing at Mumbai High Court. In the legal awareness series for the citizen of this country, we are going to discuss about various provisions, landmark judgments and relevant practice notes in respect of the legal provisions. Today we are going to discuss about what is FIR and what are the remedies if FIR is not registered by the police. We are going to discuss the landmark judgment on FIR. Apart from that, I am going to tell the interesting incidents in my practice in respect of FIR. As far as FIR is concerned, police officer is required to record the information in respect of cognizable case or cognizable offence. When the informant goes to police for registration of complaint or FIR, and when there is a cognizable offence, it is mandatory for police to register an FIR. In case of cognizable offences, police are empowered to arrest the person without any warrant from the magistrate. Now, this being the legal provision under section 154, the police officer many times don't register FIR even though cognizable case is made out. Even though there is a cognizable offence, they, because of some political influence, they deny to register FIR. In such cases, what are the remedies available? In case the police is denying to register FIR, we can write down to the commissioner or the superintendent of police of that concerned police station who is having supervision over that police station. And if, even though after filing complaint with the SP, if the offence is not registered, in such situation, we can file a writ petition before the High Court for registration of FIR. Now, as far as registration of FIR in cognizable case is concerned, there is a Supreme Court judgment in case of Lalita Kumari versus State of Uttar Pradesh. The 5 judges bench of the Supreme Court had laid down the guidelines in respect of registration of FIR. The Supreme Court has said that whenever there is a disclosure of cognizable offence to the police officer, they have to mandatorily register an FIR. If they deny to register FIR, then police is also liable, or they can also face departmental inquiry. If any offence is there which police is having doubt that whether it discloses not cognizable case or not, then in such situation preliminary inquiry can be conducted, and the preliminary inquiry has to result in the registration of the FIR. It is the duty of the police officer to register an FIR if there is a disclosure of cognizable case. And there are some cases in which there is a delay in registration of FIR. If there is delay of more than 3 months, then preliminary inquiry is mandatory. Supreme Court in Lalita Kumari's case had laid down a guideline that in cases of corruption, matrimonial dispute, commercial dispute and medical negligence cases, preliminary inquiry is necessary. Preliminary inquiry is also defined in the Lalita Kumari judgment, stating that it is an inquiry to verify or to ascertain whether the information reveals the cognizable case or not. This is the only preliminary inquiry definition which is given. So, as far as Lalita Kumari judgment is concerned, this is very important judgment which actually enables the citizen of this country to invoke the law and get the FIR registered in case there is a cognizable case or cognizable offence occurred. Now, there is an interesting story which occurred in my case, wherein there was a written complaint given to the police station in respect of 307 offence. But while registering an FIR, police had dropped the particular incidents in respect of 307, and therefore 307 is not registered, or the offence under 307 was not registered. When this fact is discussed before the court has asked that what is FIR? FIR is the written information given to the police officer and not what is recorded by the police officer. Now, if there is a manipulation in writing the FIR, then we can definitely point out if our case or if our complaint discloses the cognizable case and FIR doesn't discloses the particular set of offences, then in such situation we can definitely point out to the court that the police have manipulated the FIR, and under the influence or under the political pressure, many times police doesn't record what is what is written in the complaint, and that is not reflected in the FIR. So section 154 is very important, and there is a Lalita Kumari judgment. We are giving this Lalita Kumari judgment in the description of this video. Thank you.